One of the topics I want to talk about today is the uncomfortable topic of sentencing. In United States District Court in Tucson, over 98% of all cases are resolved in a plea agreement. And what your sentencing is depends on a huge number of factors. In federal court, they have what they call the Federal Sentencing Guidelines. They were brought out in 1984. They used to be mandatory. They are not anymore. The United States Supreme Court said they are advisory, but a judge has to calculate what your term would be. It was an attempt by the feds to standardize sentencing because in Tucson, Arizona, they might treat 100 pounds of marijuana a lot differently than they do in Chicago. So the Congress tried to standardize things. The problem is you're dealing with people. People are snowflakes. They're all different. They're all different situations. Sentencing in federal courts used to be almost probation available on everything. But then in 1975 came the Get Tough on Crime. The prosecutors went to the legislature and said, these judges are not tough on crime. We need mandatory prison sentences. So now you have prosecutors, some of them right out of law school, handing out 5 years, 10 years, 15 years on these things. So a lot of times a sentencing is, you can get a good result depending on the groundwork you do before you get in there. A lot of times you might have a motion to suppress. Maybe good, maybe not so good. A lot of times you file it anyway. And the reason you did is twofold. One, in case the thing goes to trial, there's a conviction, there is a record for you on the appeal. So you have something to argue to a higher court. Another reason is a type of poker. You're showing a card to the prosecutor that they will start thinking about, maybe this is not as clear-cut as I thought it was. And that affects plea bargaining. That affects the method that sentences are handed out. A lot of states now have gone to mandatory sentences, but there is a movement afoot to get rid of those things. The judges are in the best position to tell. And the prosecutors are in no better position to say who's bad, who's not, who needs to be locked up, and who needs to be a chance on probation. When I started practicing in 1975, you could go to prison for a baggie of marijuana. What happened, of course, is the legislators' kids started getting busted. They said, that's harsh. What happened now is you have medical marijuana. You have a lot of states legalizing marijuana. The feds still treat marijuana as a Schedule II substance, which means you can still get a huge amount of time for that. But again, the factors such as your historic record, your mental health, your substance abuse, if any, all these factors are put together in what's called a sentencing memorandum that the defense makes. And you present it to the court, witnesses if necessary, particularly if you have reports from doctors, psychologists or psychiatrists that have a input from examining the defendant. There is a multitude of factors. The most common question I get, how much time am I going to get? I don't know, because there's too many factors that go into that. You have to look at the facts in the case, the factors that bear on sentencing, and mitigation and aggravation. Do you have a history of criminal record? That is aggravation. Did you come from an addictive background? Parents, siblings, all of these things have to get worked into that. And usually I get that question at the beginning of a case before I've read one word of one police report. So is the sentencing going to be? Maybe none. Maybe a lot less than you would ordinarily if you walked in there and pled guilty.